Good morning, ladies and gentlemen. Welcome to PVL 2601. For today's session, we will be focusing on study unit 19, titled Parental Responsibilities and Rights. So in terms of the common law, parents have parental authority over their children, which gives parents rights and power and duties and responsibilities in respect of their minor children and the children's property too. Section 1, subsection 1 of the Children's Act uses the term parental responsibility. So as you all know that with raising children, there should be a guardian. There should be guardianship. It could either be from the parents or as someone being appointed as a guardian. So according to section 1833 of the Children's Act, it refers to guardianship as the administration and safeguarding of a child's property and child's property interest in assisting or representing the child in administrative, contractual, and other legal matters, also giving or refusing consent legally required in respect of the child. So this is basically what it means to be a guardian. It means that the person who will be appointed as a guardian should be able to minister, administrate, safeguard, assist and represent the child in matters concerning administrative contracts that the child may be entering into. In this case, for example, a minor can enter into a contract regarding maybe an advertising job, for example, where they become a model for, say, for example, Mr. Price. So that person who is acting as their guardian will be assisting the child and as representing the child regarding to such contractual issues and legal matters too. For example, if, say, for example, the child wants to not necessarily sue, but then is interested in a certain matter, and that matter involves the child can also be assisted by the guardian to work on that legal matter. The guardian also is given the right to refuse consent to legal to any matter regarding the child if her refusal is in the best interest of the child. So a parent is not entitled to compensation for controlling the child's estate and obliged to control the estate like the prudent or diligent person. So should the parent fail, the child can sue the parent for intellectual damages. So in this instance where the child would have to sue the parent, they must be guided. So a guardian, that's where the guardian who's not a parent comes through to assist the child in claiming or suing for intellectual damages against their parent or whoever who might have failed to perform in the best interest of the child in that matter. In a case where a child is about to be married, adopted, or deported from, or been deported from South Africa, the guardian must consider any views or wishes expressed by the child. In this instance, the voice of the child is more important, whereby the child is given an opportunity to say their views or their wishes or how they feel about the matter. So that will also be brought into whatever situation that they might find themselves. For example, if they are in a case hearing, a court hearing rather, or in a mediation hearing, the views of the child would also be considered. The parental responsibilities and the rights also includes the care. Section 1, subsection 1 of the Children's Act defined care as providing the child with suitable place to live, conducive to the child's health, the child's well-being, the development of the child, and the necessary financial support needed. Safeguarding and promoting the child's welfare or well-being protects the child from maltreatment, abuse, neglect, degradation, discrimination, respecting and securing the fulfillment of the child's constitutional rights and rights set out in the Children's Act. Guiding and directing the child's education it's also part of caring for the child. Advising, assisting the child in his or her decision making, bearing in mind their age, maturity, and stage of development. Guiding the behavior of the child is a human matter or in a human manner. Maintaining a sound relationship with the child and ensuring the best interest of the child concerning all matters. So, like we did previously say that in every matter that involves the child, the best interest of the child is most paramount concern. So it's of importance that whatever decision that should be taken or will be taken should be the best interest of the child should be considered. The person who has care may decide where the child may reside, with whom the child may associate with, decide on the school, whether the child should embark on a tertiary education journey, the religious education for the child, and social events. So what this means is that if the court awards a certain person the right to care for the child, or rather the parental responsibility and rights of the child under the care and placing the care of the child in that person's possession, the person has to consider where the child will reside. It's their responsibility to look out for that. Also to see and allow who the child associate themselves with, whether it's good influence for the child or bad influence of the child. Decide also whether on which school it's best for the child to go to, and whether the child can embark on a tertiary education or not. The religious education, meaning that what kind of information regarding religion you prefer as a caregiver of the child that the child should receive. And also social events that the child would be partaking in or attending to, the language in which you prefer as a caregiver of the child to raise that child with. It's either maybe you're going to choose whether a native language of the child or another native language of the child or any other language you prefer the child to be raised in. And also which medical treatment the child should take. For example, if your child was taken to a doctor and the doctor was to say the child has to go to a surgical or have a surgical procedure done to them, it is you who is responsible for the child's care. So it's your decision whether the child would partake in that surgical procedure or not. The caregiver can still discipline the child in a moderate or reasonable corporal punishment, meaning that the disciplinary of a child, for example, say for the child acted in a way that improper, how you're going to discipline the child should follow a moderate and reasonable corporal punishment, meaning that whatever disciplinary method that you use should not be abusive or aggressive to the child. They also need to consider the views and wishes of the child. Like we said, the paramount importance when concerning a child is their best interest. So in every situation, if the caring method that you are bringing to the table or consider should be of the best interest of the child. In Martin versus Mason case, it was of divorced parents who disagreed on the school their child should attend to. So the court was then asked to select a school, but the court refused and held that only the duty was not properly performed and the court may intervene. So the court was saying that when the parents do not follow the proper duty, that is when the court would intervene. However, it was the parents' responsibility to decide and come to a mutual condition, a mutual decision of whether the child has to, which school the child had to attend to. So the third parental responsibility and right is contact. This refers to maintaining a personal relationship and communication with the child on a regular basis, which may be done in person or through video calls, telephone calls, letters, emails, SMSs, etc. In the case heard by the court, the case of Alsop, the court held that the father whom contact has been awarded may give children religious instruction even if they differ from those of their caregiving parent. Basically, what the court was saying in this case was that since the father was awarded the contact responsibility and right over the children, they also were given a right that they may give religious instructions to the child, even if they were different from the one given by the parent who was awarded the caregiving responsibility and right over the children. So the court can either give you, as a parent, all the parental responsibilities and right, or the other parent may receive the care or the guardianship or the contact, or the other parent may also get the contact, a parental responsibility and right only. Another parental responsibility and right is maintenance. Maintenance in this case concerning the child involves food, clothing, accommodation, medical care, suitable education. Those qualify as maintenance. However, the duty to support the child depends on the circumstances of every case. So every case, as you know, has its own merits. It could be that in this case, the child needs maintenance regarding suitable education. You find that the other parent was able to maintain the child with food, with clothing, with accommodation, and medical care. Now, the only maintenance that is required from the other parent is that of education. So that also falls under maintenance. It's either you can go and apply for all those necessary needs that fall under the maintenance for the child, or you can select certain maintenance issues, or rather rights that you feel the child would need, and you are asking the court to assist in interacting with the other parent to supply the child with. There are factors which should be considered, obviously, when a maintenance order is brought regarding the child's need, which also include the needs of the child, what that child needs. It could be accommodation, as I mentioned before. It could be food, it could be clothing, it could be medical care or education, etc. Also, the age of the child is also considered by the court when a maintenance is to be approved or refused. The state health of the child, and also the state health of the person the maintenance is requested from, the social status of that person who the maintenance is requested from. So the barrier of the duties to support the child are that of the state, the child's parents, the child's grandparents, and the child's siblings. Lastly, a person who cares about the child but is not related to the child, and also the child's step-parents. So I'm going to give you information on every topic that I just mentioned. So the barriers of the duty of support to the child, which means that these people that I just mentioned, have the duty to support the child. Firstly, the state. The state's duty points out ways in which to meet its obligation to support children by funding grants, for example, your social grants that we have, foster grant, child grant, and the welfare programs such as the National School Nutrition Program. If you are aware of it, there are, the state actually finds out how many children are from disadvantaged homes or if have family backgrounds, and then that such schools will be awarded the nutrition program, and are also usually being awarded social workers who would also assist with the children applying for social grants. So the duty of the state is to provide funding grants that will assist in supporting the children. Those funding grants include social grants, foster child grant, welfare program grant, and national nutrition program. Now going to the barrier of the duty of the child under the child's parent. So parenthood automatically gives rise to the duty to support one's child. So it is the responsibility of both parents to support their children regardless of their marital status. As I did mention earlier, when looking at the maintenance order or application that would be brought for it to be granted, the social and mental state of the person whom the maintenance is requested from is also considered, and the income also of the person. So if the parents are not financially well or they do not have jobs, that will also be considered when applying for a maintenance order. But automatically, it is the responsibility of the parents, whether they are married to each other or not, to care and support for their children. Failure to do so, now the grandparents are then approached. Now they have this duty to support their grandchildren. The court once held paternal and maternal grandparents the liability to support their children. So where the parents fail to support their children or cannot support their children, the duty is then passed on to the grandparents. So where the grandparents fail or are not in a position to care for this child or children, now the siblings of the child are then awarded the position or the duty rather to support the child. Spiro, according to the textbook, is also of the view that a child born of married parents is not responsible for the maintenance of the siblings who are born to unmarried parents. So this was considered under the equality clause in the Constitution. And as you can see, it doesn't seem to be equal, and it tends to have this discriminatory effect. So there might be an issue regarding this fact by Sparrow, whereby it would not be considered as a favor. So the next person who would have the duty to parent or take care or duty to support this child would be a person who cares for the child but is not related to the child. For example, it could be a relative, it could be a teacher, it could be a social worker, or anybody who is aware of the child's living condition and might have the resources to help the child. Section 31 of the Children's Act governs the position of a person who has no parental responsibilities and rights in respect of a child, but voluntarily cares for the child indefinitely, temporarily, or partially. This person is obliged, such as a person, to safeguard the child's health, well-being, and the development of the child, to protect the child from maltreatment. A child who is at the end of the head of the child-headed household may have a duty to support in respect of the children in the household if they are his or her siblings. So this means that, say, for example, where the child is the head of a household, meaning that this child has other minor siblings who are younger than them. So this child also might have the responsibility to take care of those siblings. So now the barrier now goes also to the child's step parent. So for example, this child is in the states that the caregiving and the guardianship is given to the mother, and now the mother gets married. So the stepfather also has the duty now to support the child. According to common law, a step parent was not obliged to maintain his or stepchild because of affinity, does not give rise to the duty of the child in respect of one spouse or in a civil partnership. However, in a hasty case, the court held that the child's constitutional right to parental care extends to step parents and encompasses with the child's maintenance needs. So common law denied refused obligation of the step parent to take care of the stepchild. However, the court, in the case of Haystack, held that the child's constitutional right to parental care also extends to the stepchildren. So as you know that the Constitution is the supreme law of the country, so every constitutional right of one that is being infringed, it's considered unconstitutional. So in the case of MB and N versus NB, M for mama, B, and N for no, notary, B. In this court case, I'm actually trying to give you an idea of the court case, the names, because the M and the N sounds similar here when I say it out. So this is also in your textbook. So you can also check this in your textbook of this case, just to have clarity and understanding of what was said regarding matters of the child, the barrier of the duty to support under the child's step parents. The court in this case adopted a partial difference approach to hold a stepfather liable for a portion of his stepchild's school fees after the stepfather and the mother's child got divorced. So you go and check out and read the decision in this case, which might also help you in answering questions or understanding what the position of the court is regarding the child's step parent. So now we move on to recovering of expenses relating to support. So a person who supplies maintenance to a child but has no recourse against the child for any amount spent unless when the maintenance was provided, the child was de facto in a position to support him or herself. And the person who provided the maintenance intended to claim reimbursement from the child. If the act, meaning the person maintaining the child, the maintenance being the act itself, was out of a sheer liberty, he or she does not have the right to recourse, for then the maintenance was a donation. So where the act of maintenance, whereby the person was in their mind, for example, they were maintaining with the hope of being reimbursed in the future by the child, and the act was out of sheer liberality, that does not call for the right to recourse, and therefore the maintenance would then now be taken or regarded as a donation. So one should be careful about that one. Okay, where one parent can recover maintenance that they paid. That's their meaning, in this case, where their pro rata share of the maintenance, the child's maintenance, can be recovered to the parent. If this is where, for example, where the court has apportioned the duty to support between the parents. For example, if, for example, the other parent was given the duty to support the child, for example, with food and with maybe school clothes, and that parent failed to do so, and the other parent filled in and bought the child school clothes and maybe a school lunch as well for the child, and that was not what the court ordered them to do, that parent can recover the maintenance from the parent which was obliged or ordered by the court to cover that maintenance of that child, that part of maintenance of that child. Now, the liability of the parents for debts incurred in respect of their child's maintenance depends on whether or not the parents were parties to a valid marriage or a civil union and are still living together. So this would be considered where there is a third party involved. meaning if they have debtors now claiming money from them. So now the marital status of the parents would be more considered, whether they are invalid marriages or whether they have a civil union or they're still living together. A father who paid maintenance to a child he believed to be his own at the time when they were paying the maintenance, or where the court ordered that they paid the maintenance to the child, and later recovers that the child was not theirs. Now that father has the right to receive, to be repaid back, to recover the maintenance that they paid for the child they thought was their own, was their biological, but only to find later that the child is not their biological child. That parent has the right to claim that money back. In the case of M and N versus AJ, you must check in your textbook in page 309. There is the case that speaks clearly about the situation of the father. So the reciprocity of the duty of support, which means that it must go both ways, right? So the duty of the child to support his or her parents, their grandparents or siblings arises when they do not have a spouse, or not in a civil union or civil partnership, or the child can support them. So now the child, the duty lies on her or him to support their parents or their grandparents or siblings. So this duty only arises when they are not married. They do not have a spouse, they do not have a civil union, partnership. That child now would have to reciprocate the duty of support to their parents, grandparents, and siblings. So now we're going to focus on ways of acquiring parental responsibility and rights. At common law, the term parental authority has been replaced by the new parental responsibility and rights. Note that one parent may have more parental responsibility and rights than the other, or have different parental responsibilities, as I mentioned earlier. So where one parent has guardianship while the other only has the other a responsibility of care or either contact. By birth, the general rule is that the child's biological mother automatically has parental responsibilities and rights of the child to whom they give birth to. So this is regardless of whether the mother is a minor or an adult. So if the mother is less than 18 years old and married, she acquires full parental rights and responsibilities. If the mother now is a minor, unmarried, neither she or the biological father of the child has guardianship, but the guardianship now becomes the guardian now becomes the child's guardian. So it could be, for example, the maternal mother of the biological mother of the maternal mother of the maternal mother of the child's mother can be now awarded the guardianship. So which means that she now would be the child's guardian. A surrogate mother is a child surrogate in terms of the valid surrogate motherhood agreement and does not acquire parental responsibilities and rights. Only the commissioned parents will be acquired parental responsibility and rights from the moment of the birth of the child. The commissioned parents, which means those are the parents who are into the surrogate procedure, not necessarily them, but them opting for this surrogate, which means they now have a surrogate mother who would carry their child for them, and when the surrogate mother gives birth to the child, they do not even have, the surrogate mother does not have parental responsibility and rights over the child. Only the commissioning parents of that child would acquire the parental responsibility of the child when the child is born. Now, where the surrogate agreement is terminated and the surrogate mother and her spouse or partner become the child's parent the moment the child is born. So say, for example, the commissioning parent terminate the surrogate agreement. Now, the surrogate mother and their spouse or partner would become the parents of the child, meaning they would also acquire the parental responsibility and rights of the child when the child is born. Now, where the agreement is terminated, the surrogate agreement is terminated at the birth of the child, or after the birth of the child, the surrogate and their spouse become the child's parent at the termination of the agreement. A marriage or a civil union with the children's mother at the time of the child's conception or birth, or at any intervening time, the father acquires full parental responsibility and rights if he is married to the mother of the child at the time of the child's conception. A man or woman in a civil union with their biological mother when the child is conceived, born, or at any convenient time has full parental responsibilities regarding to the child. So where a marriage or a civil union between the child's parent after the child's birth, the father acquires full parental responsibilities and rights. Another way of acquiring parental responsibilities and rights are in a permanent life partnership between the parents at the time of the child's birth. So now the biological father acquires full parental responsibilities and rights if he lives with the child's mother in a permanent life partnership when the child is born. Where the parents cannot agree whether they are in a permanent life partnership when the child is born, the dispute is referred to for mediation by a family advocate, a social worker, or social services professionals, or any other suitable qualified person. So where the parents of the child cannot agree on what their marital status is, whether especially in a permanent, whether they are in a permanent lifetime partnership or not, that matter now, the dispute now is taken for mediation. So another way of acquiring parental responsibilities and rights includes acknowledging paternity, contribution to the child's upbringing, and contributing to the child's maintenance. Section 21, 1, subsection 1 subsection B of the Child Act states that an unmarried biological father acquires full parental responsibilities and rights, regardless of whether he has lived or is living with the child's mother, he consents or successfully applies to be identified as the child's father, or pays damages in terms of customary law, and the contribution that he makes regarding the child are in good faith to the maintenance of the child. So let me explain this part where it includes the damages. Okay, according in terms of customary law, where the father is where the biological father of the child is not married to the mother of the child, there's a certain amount that should be paid for the father for the, we call it damages, in regarding to the child. So the unmarried biological father now pays the biological mother's family in order for them to allow him access to see the child, maintain the child, and the child can also visit his family. So that's where the damages, the payment of damages comes from. And another way of acquiring parental responsibilities and rights includes a parental responsibility and right agreement. In this situation, it occurs where an unmarried, say for example, an unmarried biological father or any other person who is interested in the child's care, well-being, or development can obtain parental responsibilities and rights of a child. Usually this is done in a form, it must be in a written format and must contain the particulars prescribed by the regulation under the Act. It must also be registered. This agreement must also be registered by the family advocate or made an court order at the application of the parties and can only be terminated or amended by the family advocate or the court. So this means that the interested party or the unmarried biological father of the child can also have the parental responsibility and right agreement, meaning that they would write what they are agreeing to parenting the child with, considering the needs of the child, considering their age and so forth. Remember, we did mention it earlier that when considering and when approving or refusing, or yes, refusal of a maintenance order, the age and the needs of the child are the ones that are being considered when approving or the refusing of a maintenance order. So in this case, in this agreement, the parental responsibility and rights agreement, the party who wants to contribute to the maintenance of the child, in that agreement, they should state what they are willing to provide for the child. This document must be taken to the family advocate, and that application must also be that application can be registered by the family advocate or the court. And if the family advocate registers the agreement, and he or she may amend or terminate on the application by the person with parental responsibility and rights in respect of the child, and the child with the court's consent. So for example, if the child wants to amend certain things in the agreement with the advocate's presence, they can also do that with the consent of the court. So now the assignment by an order of the court. So where when a person does not have a parental responsibilities and rights, this person may acquire them by means of a court order. So Section 23 of the Child's Act states that a person of interest in the child's care, well-being, and development may approach the High Court or the Regional Court or the Children's Court for an order awarding contact or care to the child, and the factors taken into account are the best interest of the child, the relationship between the applicant and the child, the relationship between any other relevant person and the child, the degree of the commitment the applicant has shown towards the child, the extent to which the applicant has contributed to the expenses in connection to the child's birth and maintenance, and any factors to be taken into account on the opinion of the court. So those are the factors that the court will consider when awarding, or when one approaches the court insisting on or desiring on acquiring parental responsibilities and rights of the child. Those are the things that the court will look into. Now, Section 28, subsection 2 of the Child's Act authorizes combining an application for termination, extension, suspension, or circumscription of parental responsibilities and rights, and an application for the assignment of the child and contact. So meaning an unmarried father can ask the child to suspend particular aspects of the mother's care and assign them to them. So appointment in a will. So Section 27 of the Child's Act states that a person who has sole guardianship of the child or the care or has been appointed as a fit and proper person to take care of a child can or may appoint a fit and proper person to act as his or her successor after their death, which may be done in a will. So Section 5, subsection 3 of the Matrimonial Property Act permits a parent to nominate a person to act as his or her successor after his or her death. Now, the Administration of Estate Act states that if a child is born of married parents, letter of tutorship or guardianship will be issued to the person the child's parent obtained as a child's testamentary guardian or custodian. So now if the child is born of unmarried parent, the person the mother appoints will be the child's testamentary guardian or custodian. Now the adoption. It is the last way a person can acquire a full parental responsibilities and rights in respect of a child. An adopted child, only a minor can be adopted under the following circumstances. Such a child is an orphan and has no caregivers or guardians willing to adopt them, or the whereabouts of their parents, of the child's parents or guardian cannot be established, or where the child has been abandoned, or the child has parents and guardians who are abusive and intentionally neglect the child. So the adoptive parents, spouses in a civil union, permanent in a domestic life partnership, civil union partners, and other persons sharing common household and forming a permanent family unit may jointly adopt a child. A widow or widower, a divorced person, or a unmarried person in common law, these people were not allowed to adopt or foster for a child. However, that has changed. These people now, this group of persons now may adopt a child by their own without a partner, and the child's foster and so sorry, the child's foster parent also adopt the child. Child born of unmarried parents, the father can adopt his own child. The potential adoptive parents may apply for an adoption order in the prescribed manner at the children's court. Application must be accompanied by both report by any adoptive social worker and the letter from the provincial head of Department of Social Development recommending the adoption of the child. So now consent is required of all guardians of the child for the adoption of the child. Both parents and need to consent to the child as well. And if they share a guardianship and the capacity of the parent and guardianship, we did also mention in study unit 1 the valid requirement of a civil marriage, which included capacity. So the capacity of the child, of the parents or the people consenting to the adoption will also be examined as well. So advertisement and payment for the adoption will also be considered as well. The effect of an adoption order terminates previous orders and all parental responsibilities and rights any person might have heard before the adoption. Now, the position when more than one person has parental responsibilities and rights in respect of a child. One person can exercise those rights without the other person unless the Child's Act or the court order provides otherwise. The guardianship, under guardianship, Section 18, subsection 5 and 3C of the Child Act requires the consent of all the child's guardian for the following juristic acts of the marriage: the child's adoption, the child's departure or removal from South Africa, the child's application for a support, and the alienation or encumbrance of any immovable property of the child. Due to consideration of the views and the wishes of the other co-holders of the parental responsibilities and agreement, Section 31, subsection 2 of the Child's Act states that a person holding parental responsibilities and right must give any decision which likely signifies the changes or have adverse effects on a co-holder's exercise a parental responsibility and right. So one can surrender or transfer the parental responsibilities and rights is prohibited. Remember, I just mentioned how the parent who was in the care of the child can appoint a new guardian in their will, and that person will occupy those responsibilities after their death. So in this case, when one is still alive, they cannot surrender or transfer their parental responsibilities and rights. Co-holders may agree that one of them will exercise any or all of their rights and responsibilities on behalf of the other co-holder. So this will also be including a parental plan. So that we now, which means that the parties now have to come together and have a parental plan. Usually we do this in mediation, in family mediation, where a family mediator is approached and they draft a parental plan, and then that is given to the, what do you call this, to the family advocate, who then takes it and registers it, and then it becomes a court order. So now, termination of parental responsibilities and rights. Most aspects of parental responsibilities and rights are terminated at the death of the parent. However, the child can still claim maintenance from their parent's deceased estate. Termination of duty to support by the death of the child, the death of the adopted child, the death of the child becoming, the child becoming self-supportive. So where the child now has become financially stable or capable of taking care of themselves, that is where the duty to support by the person who was supporting or maintaining them ends. Now, the child entering into a civil marriage or a civil union where they are a liable party is declared insolvent. So now, no. So now, where the child enters into a civil marriage or a civil union, the duty of support terminates there. Where the child or where the liable party, the person who the maintenance is requested from, is declared insolvent, that's when the termination of support comes through. Termination of an order regarding the child's maintenance. If the maintenance court or the court order or the court itself, any other court besides the maintenance court, orders and stipulates that a maintenance must be paid until the child reaches a certain age. However, if the child is not financially fit to support themselves, the order continues until the child is financially fit to support themselves. The order will then only lapse when the child becomes self-supportive, or even if that is before the child reaches a specific age which is mentioned in the maintenance order. For example, if the maintenance order stipulates that the child was to get maintenance until the age of 30 or 25, and then now this child becomes self-supporting before they reach 25. Let's say when they reach 23, this child who was being who was maintained by a parent or a guardian now is financially fit. That is when the termination. That is when the support is terminated. I hope this was informative. You can share your questions in the description box. All the best with your exams.